Hey, Jenny Bradley here, founder of Triangle Smart Divorce.
I'm Katie Kober, one of the attorneys at Triangle Smart Divorce.
And Katie, you've had a lot of experience with folks who have inherited wealth. So I have you here today to help answer some questions we get a fair amount when people call our office. I'm married, I have some inheritance, I really want to protect it. What do I need to do?
I mean,
Sounds simple.
sounds simple, but people screw it up all the time.
Okay. And so let's talk a little bit about why it's not as simple as it should be. Because, you and I were talking before we started that, hey, I got $250,000. It's in this separate account. That's mine, right? Well, you have to ask a lot more questions, don't you? Because we lawyers like to say it depends.
Right.
So what does it depend on?
I think it depends on a number of things. So for your example, someone inherits $250,000. We're going to ask, did you put it in a separate account? Did you then commingle, which would be adding marital funds into that account?
What are marital funds?
So the most common example would be like income, right? From your day-to-day job, you and your spouse's job. And then how has this $250,000 been managed? Have you taken active steps in terms of trying to grow it? Because if so, then a portion of that is going to be marital.
And that's the one, frankly, kind of angers me. But this is our law in North Carolina. You have $250,000, you opened a separate account, you put it over there, you never put any money in it that was earned during the marriage. You didn't do anything other than it was at Vanguard or Fidelity or somewhere, and you're smart. You like spreadsheets, you like following the markets and the stocks and everything, and you make decisions about where to invest it, and our case law says then some of this has become marital property because you spent marital time and talent growing the money?
Right. Yeah. I mean, it does feel very unfair. But unfortunately, that is what the law is. And then it becomes a huge mess determining what portion is marital. Because it doesn't convert the entire account to marital, but determining what that amount is can be very difficult.
So how can someone avoid that? How can they grow their money and not make it become marital?
I mean, the most straightforward ways would be to have, a broker do it for you. And then you're stuck paying that fee.
You're paying a broker to manage your assets.
Mm-hmm.
Hoping, obviously, that they grow it a lot more than that to cover the cost.
Right.
And grow it more than you personally could have.
Right. And I think some people would say, no, they would do a better job. But if you want to protect it, that's going to be the best way to do it.
Okay. What if someone had this, let's just stick with the $250,000. Someone had this $250,000, they did what you said, they opened a separate account, they put it in the separate account, but they put money in it from their salary. How do you go about teasing that out now that the account is what we would call mixed, part marital, part separate?
Well, I think if you're at the settlement stage where you're doing it outside of court, then we have a ton of options, okay, right, for determining what portion is going to be attributed to marital and what's going to be separate. And then when we're in court, you're gonna use a calculation. I mean, if you might even just hire an expert, depending on the amount that's at stake. Because obviously hiring an expert is going to cost money, and you don't want to spend more to get less.
Right, right. And the kind of expert you would hire, would this be an accountant or a broker or a financial advisor or any of these?
Well, first, you're going to have to talk to in your specific situation, figure out who is going to be qualified to do it. But yeah, we've had it in the past where financial advisors have given us great information that has been well-founded, in math and not just, oh, this is what I feel like. You could do a CPA. I think you have a number of options. I think it would depend on, again, how the account is situated and what type of growth we're talking about.
Okay. And this isn't just inherited stock accounts. It can also be inherited IRAs.
Yeah.
Right? And so in addition to inherited cash, you can have an IRA that perhaps was already in payout status, and your parent has died and you step in there and you're now getting these mandatory distributions that you have to take at a certain age from the IRA in a certain period of time from the IRA. What would someone do with these distributions that they're getting from the IRA to protect those?
So if they didn't want to use the distribution for like day-to-day living expenses, then we would tell them to set up a separate account, put that in there. And again, don't commingle it. Just keep those funds in that account. I think the biggest misconception that people that come into the office have is that if they know the number that they spent, that it keeps it separate. So for example, people typically come in and say, well, when we bought the house, we used $60,000 that I got from an inheritance from my dad. And you're like, okay. And they're like, so that's automatically separate. And we're like, well, no, that's not how it works anymore. Or people,
or ever.
or yeah, or that's just how people think on the street, right? That I know what the number is, so that makes it separate. Or they get an inheritance and they deposit it into the joint savings accounts. And they think, well, 10 years ago, I deposited $100,000. Now the account has 200, so 100's automatically mine, which we know is not how that works either, because it is impossible to trace every one of those dollars of the $100,000.
First of all, it's unlikely, for most of our clients anyway, that they have every single bank account or statement that is needed to trace every single one of these dollars to begin with, which is part of what makes this difficult. So I would also say a good way someone can protect their assets is to keep every single statement if they are commingling.
Yeah.
Which nobody wants to hear, but it's the truth.
But even with every single statement, once you start pulling money from that account, there's no way to say, you know, these $2 came from the inheritance and this $2 came from my income.
And there's no presumption that it's marital money out first?
No. Walzik used to always just shut it down in court.
So one of our former judges on the family court bench here in Wake County would say, like, you can't tell me a dollar doesn't have an intent.
Right.
A dollar is a dollar. And you spent it, it's gone. We're not going to talk about tracing it back.
Right.
And so we're going to talk about what's left in it and maybe apply a percentage or maybe do a tracing.
And she was right. I mean, there's no argument against that. That is just the correct position. And I think a lot of people are, you know, when they get the inheritance, maybe their marriage is in a better spot. So they were fine to make it ours, right? What's mine is yours.
Right.
And then when you get to the point that you need us, it's less friendly. And suddenly you want to claw that back. And the only way to do it is to have kept it separate from the jump.
And I think to go back and touch on something you said about real estate, because everybody might not know this either. I know we do, but we spend a lot of time and energy and money learning the law and paying off loans to go to law school. So for those people out there who aren't, there is a presumption in North Carolina that when you buy a house and you put it in this particular way of holding it called tenancy by the entireties, that you made a gift to the marriage when you put that $60,000 down on that house.
Right.
Absolutely, positively a gift to the marriage, unless you have something in writing at the same time of that process that says, no, this is not intended to be a gift to the marriage.
Right.
And I think a lot of real estate lawyers out there don't tell people that when they say, let's title the house this way.
Yeah, I mean, I don't think anybody, right, at that time is telling people that. They just want to know, well, I mean, your mortgage lender just wants to know where the money came from, right? Not, is this yours? Is this his? Just, hey, we just want to make sure this down payment is valid and it wasn't a gift from somebody else. Nobody's saying, hey, by doing this, you're commingling and it's losing its separate nature.
And that's not to knock on real estate lawyers, because they're thinking there's more protections about holding the house under this title.
Right.
There are protections from separate creditors. There's inheritance that instantly happens, as opposed to if you owned it as just simple joint tenants or tenants in common even, and those types of things. And so they're not trying to screw you out of your inheritance, if you will. They're just trying to protect the house as best as possible, because that's their job. Nobody goes into buying a house often thinking about what happens if this doesn't work out.
Right.
But they should, so that probably brings up premarital agreements if you came into money before you get married and you buy this house we're talking about.
Right. Yeah. I mean, a prenup would be great, or even if you haven't come into the money yet, but you know that you will be.
Okay. And in a prenup, we can, how do I want to say it, contract around all these things you and I have spent time talking about. We can say, if separate money goes in that house, it doesn't matter how the house is titled, you're going to get X dollars back or X percentage of the proceeds if it sells. whether there's a divorce or not, or only if there's a divorce,
Right.
and all of these things. If you put it into an account and you actively manage it, doesn't matter. That's still going to be your separate property.
Yeah, certainly the prenup, there's a ton of safeguards that we can put in there that would not apply without one.
And if you're already married and you're coming into inheritance, you could do what we call a postnup, which is not an agreement that says we're getting divorced and this is what we're doing. It's an agreement to put in place just about assets.
Right.
Could be about debts too, I guess.
Yeah.
Just about property. That can have these same contracting around the law kind of thing, so that you can decide what should happen with your separate property, not some court of North Carolina with their, frankly, I think, outdated rules that aren't realistic.
Right. And the prenup and postnup, I feel like sometimes get a bad rep in that you're planning for divorce, but they can be designed to protect both parties.
Yes.
Like they're mutually beneficial, not just in one party's favor.
That's true, because it's not to say just because you have inheritance today doesn't mean your spouse might not have some 10 years or 15 years from now.
Right.
So you could have the same rules in place for both of your inheritances.
Right.
Okay, well, I heard you say co-mingle at least 10 times, so I'm going to guess that's what you say would be the single biggest mistake that people make about their
Absolutely.
inheritance.
Yeah.
All right,